Welcome to Law Family. This video is helpful to the law students and newly practicing young advocates only. Today, we discuss about the sections 67 and 68 of B.S.A.Act 2023. Corresponding law section is 68 and 69 of Indian Evidence Act. Section 67 of B.S.A. Act, corresponding law section is 68 of Evidence Act. Proof of execution of document required by law to be attested. If a document is required by law to be attested, it shall not be used as evidence until one attesting witness at least has been called for the purpose of proving its execution. If there be an attesting witness alive and subjected to the process of the court and capable of giving evidence. Important point. Provided that if it shall not be provided that it shall not be necessary to call an attesting witness in proof of the execution of any document, not being a will which has been registered in accordance with the provisions of the Indian Registration Act 1908 unless its execution by the person by whom it purports to have been executed is specially denied. Section 68 of B.S.A. Act corresponding section corresponding law section is 69 of Indian Evidence Act. Proof where no attesting witness found. If no such attesting witness can be found, it must be proved that the attestation of one attesting witness at least is in his handwriting and that the signature of the person executing the document is in the handwriting of that person.
Welcome. Important cases. First case. A scribe can be an attesting witness also. The fact that he signed as an attesting witness must be duly proved. Second case. Certificate endorsed on a registered deed by a registering officer is relevant piece of evidence for providing its execution, but it is not full proof of execution of document. Third case, attesting witness at least only attesting witness attests only that the document was prepared in his presence and does not vouchsafe the correctness of the contents of document. Fourth guy. Fourth case, unregistered sale deed cannot be admitted in evidence to prove title, but can admitted for collateral purpose, that is possession and nature of possession. Fifth case, an unregistered sale deed can be admitted as evidence in a suit for a specific performance, but not to prove ownership. Section 49 of Registration Act allows an unregistered document to be received as evidence of a collect in a suit for specific performance. Document to be received as evidence of a contract in a suit for specific performance. The document can also be used as evidence for any collateral transaction that does not require registration. 6. Meaning of attestation. An attesting witness is one who signs the document in the presence of the executant after seeing the execution of the document or after receiving a personal acknowledgement from the executant as regards the execution of the document. Then once repeat, a, pers- a personal acknowledgement from the executant as regards the execution of the document. Legal requirement. Certain legal documents, mortgages, wills require attestation to be valid, while other like sales or lease, no need of attestation, that is not important. Seventh, attestation of wills.
Seventh one is attestation of wills. Deceased signing and executing will in presence of witness, witness putting their signatures in pursuance of in presence of deceased. Witness putting their signatures in presence of deceased. Advocate drafting will putting his signature after seeing that executant and other two witnesses have put their signatures on will in presence of each other. Will was properly attested. Naturally, eighth one is naturally the courts start with the suspicion and presence of such suspicious circumstances tend to make initial burden very heavy, and unless it is a satisfactory discharge, the propounder has a burden of proving the initial honors to remove any such legitimate doubts on the suspicious matter. Ninth one is a wife not able to discharge that heavy onus and the alleged execution of the will in her favor by her deceased husband was not proved. Consequently, she was not entitled to a probate. Tenth one is expert opinion not useful to prove the validity of the execution of will. 11th one is when will or a document need not be proved. When will or a document need not be proved. Section 53 of B.S.A. Act 2023, corresponding law section is 58 of Indian Evidence Act, has to be read as overriding section 67 of B.S.A. Act. Corresponding law section is 68 of Evidence Act. Facts admitted need not be proved.
Section 68 of B.S.A. Act 2023, corresponding law section 69 of Evidence Act, proof where no attesting witness found. The section explains proof where no attesting witness found. Case 1. Identification of signature not necessary to prove a document. Important. Identification of signature not necessary to prove a document. Will was executed in presence of witness. Identification of signatures of executant and attesting witnesses by him would not be required to prove the will. Case 2. Where attesting witness cannot be found. Case 2. Where attesting witness cannot be found. It must be proved that the attestation of at least one witness is in their own handwriting and the signature of the person executing the document is also in the witness handwriting. This applies in situations where the witnesses dead, out of jurisdiction, physically or mentally incapacitated or otherwise unavailable. This video is purely theory. The Honorable Court decides each case on merits. Thank you.
Thank you.